For decades, America told itself a comforting story. That segregation was a closed chapter, that the hard battles were behind us. That history somehow only moved forward. But this week, quietly, almost bureaucratically, that story cracked again. And what happened in Louisiana is not a footnote, it is a signal. A federal judge, at the request of the Justice Department, lifted a school desegregation order that has stood since 1967. The argument was simple. There have been no disputes, no lawsuits, no noise. But silence is not the same as justice. As Justice Ruth Bader Ginsburg once warned, abandoning protections because nothing has gone wrong yet is like throwing away your umbrella in the rain because you're not wet. If you care about how power really works and how it retreats when no one is watching, stay with me. Share this conversation. Because what looks like administrative cleanup may be something far more consequential. And to understand why, we need to slow down and look at what these decrees were really built to prevent. To see the stakes clearly, we have to define the problem precisely. This is not just about one parish in Louisiana. It is about what happens when enforcement disappears quietly without a crisis forcing the debate. The consent decree in DeSoto Parish did not exist by accident. It existed because years after Brown versus Board of Education, the federal government concluded that segregation was still happening. Not rhetorically, structurally, systemically. These decrees were designed to do one thing: deter behavior before it re-emerged. They were guardrails, not punishments. Their success was measured by what did not happen. The Trump administration's logic turns that idea upside down. If there are no disputes, the decree must be unnecessary. If no one is suing, discrimination must be gone. But history tells us something very different. In matters of race, silence is often the product of power, fatigue, or fear not equality. So the real question is not whether conflict has vanished. It is whether the conditions that once produced segregation have truly disappeared. And to answer that, we need to go back to the moment these protections were created and why they were never meant to expire quietly. To understand why these decrees existed for so long, we have to return to the original moment of failure. In 1954, Brown versus Board of Education declared school segregation unconstitutional. The ruling was clear. The reality was not. Across the South, compliance was delayed, diluted, or outright resisted. Segregation didn't vanish. It adapted. By 1967, more than a decade later, federal investigators concluded that DeSoto Parish schools were still segregated. That is when the consent decree was imposed. Not as symbolism, as correction. These decrees emerged from a hard-earned lesson. Discrimination rarely survives through open defiance. It survives through systems, attendance zones, resource allocation, administrative discretion, all race-neutral on paper, all deeply racial in outcome. That is why desegregation enforcement followed economic logic. Left alone, systems revert to equilibrium. And in America, that equilibrium has often meant separation by race and class. The decree was never meant to solve racism once and for all. It was meant to interrupt a cycle. And that brings us to the present moment. Because what happens when you remove an interruption without changing the underlying system is not neutrality. It is relapse. And that relapse did not begin quietly. It arrived with a deliberate decision, one that signaled a much larger shift. The first rupture came not with a riot or a ruling from the Supreme Court, but with a motion filed in plain legal language. This week, a federal judge approved a joint request from Louisiana and the U.S. Justice Department to dismiss the DeSoto Parish case. The lawsuit, filed in 1967, was declared complete. Closed. History, in their view, resolved. Louisiana's Attorney General celebrated the decision. DeSoto Parish has its school system back, she said. No disputes for 10 years, she argued. No conflict, no need. But that logic carries a dangerous implication. that justice is temporary, that vigilance is optional, that systems which once produced discrimination somehow correct themselves without pressure. The Justice Department offered no evidence that segregation is gone now or in the future, only that no one is currently fighting. This was not an isolated decision. It was the second such dismissal in Louisiana since the department began reversing cases it once championed. A pattern, not a coincidence. If this feels technical, even boring, that's the point. Power often moves fastest when it attracts the least attention. So pause here. If this matters to you, don't just listen, engage. These moments shape the future quietly. Because once the decree is gone, what replaces it is not neutrality. It is whatever the system was already inclined to become. And that inclination is the story we need to decode next. What's happening here is not chaos. It is design. Consent decrees work because they change incentives. They force school districts to think twice, to document decisions, to anticipate scrutiny. In other words, they make discrimination costly before it becomes visible. Remove that pressure, and behavior doesn't need to become openly racist to shift outcomes. It only needs to follow convenience. Budgets flow where resistance is lowest. Boundaries harden. Demographics drift. Patterns reassert themselves. That is the hidden mechanism. Segregation today rarely announces itself. It emerges through thousands of small, defensible decisions that, taken together, reproduce the same results. The Trump administration understands this, which is why it hasn't argued that segregation never happened or even that it was wrong. It has simply reframed the question. Not is discrimination possible, but is anyone complaining? That reframing is powerful. It transforms civil rights enforcement from a proactive duty into a reactive nuisance. And once enforcement becomes reactive, history shows what follows. We've seen this logic before. When oversight fades, inequalities widen quietly, predictably, legally. So the removal of a decree is not an endpoint. It is a release valve, a signal that the system is once again trusted to police itself. And that brings us to the next moment of escalation, when this logic moved beyond schools and into the architecture of federal power itself. The second escalation didn't arrive in a courtroom. It arrived through policy, language, and through omission. Earlier this year, the administration removed language that barred federal contractors from operating segregated facilities. On paper, it looked procedural, a cleanup, a revision. In reality, it marked a philosophical shift. At the same time, the Justice Department moved to quash another desegregation decree in Louisiana's Plaquemines Parish. Different district, same logic, oversight withdrawn, responsibility returned, evidence unnecessary. Taken together, these moves form a pattern. Not loud, not radical, but cumulative. When enforcement is dismantled across institutions, schools, contractors, civil rights oversight, the effect is not isolated. It compounds. Each rollback lowers the political and moral cost of the next one. This is how systems change, not through one dramatic decision, but through a sequence of plausibly deniable steps. Civil rights activists and parents warned that segregation had not disappeared in their communities. Their testimony was not rebutted, it was bypassed. And that is the crisis. Not that discrimination was proven absent, but that proof was no longer required. The tempo is accelerating now. Each reversal makes the next easier, each silence louder. Because once the architecture of enforcement erodes, the consequences don't appear first in policy memos. They appear in classrooms, in children's futures, in the lived experience of families who never consented to this experiment. And that is where the story turns personal. If you are a parent watching this, the consequences are not abstract. They arrive quietly. In the school your child is assigned to, in the resources that school receives, in the opportunities that narrow without anyone announcing they have done so. You are told the system is fair, that nothing is officially segregated, that if there were a problem, someone would say something. file a complaint, start a case. But that burden now falls on you. Without consent decrees, the responsibility shifts downward, from institutions to individuals, from the state to families, from power to those with the least of it. And most parents don't have the time, money, or energy to fight a system that insists nothing is wrong. This is how inequality survives in modern democracies, not through signs on doors, but through exhaustion. If this resonates, if you felt that quiet narrowing of options, don't dismiss it. Share this. Talk about it. Because silence is what systems rely on most. What's happening in Louisiana is not just local. It is a test case, and the outcome will not stop at parish lines. Because once the federal government steps back, the effects don't stay contained. They spread. And next, we need to understand how far. When the federal government retreats, the vacuum does not remain empty. It is filled by precedent. Other states are watching Louisiana closely, not because they share its history, but because they recognize the signal. If decades-old desegregation orders can be dismissed without evidence that inequality has ended, then the standard has changed everywhere. This is how domestic policy becomes global posture. America has long presented itself as a flawed but forward-moving democracy, one that confronts its past rather than erases it. Civil rights enforcement was part of that credibility. When that enforcement weakens, the message travels. Not in speeches, but in examples. Other governments notice what America chooses to stop defending. Internally, the ripple effects multiply. Local officials gain discretion. Courts see fewer guardrails. Federal agencies recalibrate priorities. None of this requires coordination. Systems align naturally when incentives shift, and the cost is not borne evenly. It falls hardest on communities with the least leverage, the fewest lawyers, the weakest voice. This is why segregation is never just a local issue. It reshapes trust in institutions, in democracy, in the promise that rules apply equally. Once that trust erodes, rebuilding it is far harder than maintaining it ever was. And now we arrive at the hardest question of all. If this trajectory continues, where does it lead? There are three possible futures, and the choice among them is not abstract. There are three paths forward, and none of them are neutral. The first is the optimistic scenario. Courts push back. Civil society mobilizes. Parents, activists, and local leaders force accountability back into the system. Consent decrees may vanish, but their spirit survives through pressure, transparency, and renewed enforcement. This path requires attention constantly. Democracy, as always, would remain work. The second is the middle path. Rollbacks continue, but unevenly. Some districts resegregate quietly. Others hold the line. Inequality grows, not everywhere, but predictably tracing old fault lines of race and class. The country adapts to this imbalance, calling it complexity, calling it federalism, calling it reality. And then there is the third path, the most dangerous one, where enforcement disappears entirely and segregation returns without needing to announce itself, not by law, but by outcome, not by hatred, but by indifference. A system that insists it is fair even as it reproduces inequality with remarkable efficiency. History suggests systems drift toward this third path unless acted upon. The future, then, is not decided by this one decree or this one administration. It is decided by whether society treats equality as a principle or as a phase. And that brings us to the final question. What exactly are we willing to protect? This is not about nostalgia for the past. It is about responsibility in the present. Every generation inherits institutions shaped by struggle. The question is never whether those institutions are imperfect. The question is whether we strengthen them or quietly let them decay. What we saw in Louisiana was not chaos, it was choice. A choice to treat equality as something already achieved, rather than something that must be actively defended. Segregation did not survive in America because it was loud. It survived because it learned to wait, to hide behind procedure, to rely on fatigue, to count on the moment when vigilance feels unnecessary. That moment may be here. The most dangerous idea in politics is not hatred. It is complacency. The belief that progress, once made, maintains itself. If this analysis challenged you, don't let it end here. Share it, question it, build on it. Because the future of equality will not be decided by courts alone, but by what citizens are willing to notice and refuse to ignore.